Alright, what's up, world? This Fresh Fetty, Highville Fetty, the nigga King Junie, uh, Fresh Out West, America Best, Mr. Ty Johnson, J Dog the Hog, and J Dog Hoggin. Murder Gang is my rap stage name, and Juke Joint Junie, and also known as Beach Malackhart or Michi. Today we are finishing off the UCC connection. It's part 3 of All Are Equal Under Law. Okay. Special stuff you should know. Taking your birth certificate to court. The courts only want to charge some bogus bonds to your federal account. And they need your bond or permission to do the discharge. Otherwise, you must pay a fine and go to jail. But they neglected to tell us that the birth certificate is the bond. The birth certificate is proof that we are the beneficiary and not the trustee of our straw man trust account. The state is the trustee. Everything, including crime and taxes, is already prepaid through the birth certificate bond. In every case so far, the charges were settled, and they let the fellow go without a record of crime by surrendering the birth certificate. Further, the birth certificate proves that you are the beneficiary of your straw man estate. The prosecutor is claiming that he represents the beneficiary, the state, when the state is already supposed to be the trustee. When the state is really supposed to be the trustee. So when you bring the birth certificate into court, you discharge all the charges against you, and you prove that you are the beneficiary of your trust estate, and this completely shuts the prosecutor down. The prosecutor now has no standing. You bringing in the birth certificate proves that he has brought fraud into the court by claiming to be the beneficiary instead of you. Only the beneficiary, you, can be the plaintiff. And you, the trustee. No. Only the beneficiary, you, can be the plaintiff. And only the trustee, the state, can be the defendant. I do not give legal advice, but this is what I would do if I were in your shoes. How to proceed. 1. Take a certified copy of your birth certificate, certified by the state, to court with you. Do not make a make a copy or it is void. Do not mark on it or it is void. Write down what you are going to say. You will be nervous and forgetful. When they call your name, walk up to the bar. Do not cross it. If it is a court of record, ask them, are we on the record? Once you are satisfied you are on the record, you can proceed. If they ask your name, ask again, are we on the record? If it's a misdemeanor, a lot of times there is no record, so just proceed. Hand the birth certificate across the bar and say, I am here on special appearance. Let the record show that the person and birth certificate has been surrendered to the court. If they will not come and take the birth certificate, then gently toss it across the bar into the well of the court. Note, a person is a legal fiction. You are a living soul. A living soul is not a person. Special appearance means that you are not giving the court jurisdiction over you. Then turn around and leave. Do not stop. Do not answer questions. When they say, hey, you stop, or you have a court date on such and such, just keep on going and get out. Do not respond. Do not come back. Do not let them bluff you into coming back. At the time of this writing, this approach is working 100% of the time. However, about 5% of the folks who do this report that the court tries to threaten them with letters. The worst that may happen is that they send you a bill for whatever you're accused of and possibly the threat of an arrest warrant. Sometimes they'll send a letter with a new court date, and the very latest was a threat letter saying that there was an arrest warrant or threatening you with arrest if you do not come in to be arraigned. However, if they could have issued an arrest us or served a warrant, they would have. So this has all been a bluff 100% of the time. Even in the letter that said there was an arrest warrant, there was one on the record, but it was never processed or served. Bluff, bluff, bluff. If you receive any of these letters, mail them back with a regular letter stating that I reserve all my rights per UCC 1-308 and I do not consent. Do not enter anything into the record or place a court heading at the top of your letter, or that will be giving consent. A regular letter only. Only once has anyone reported being grabbed while leaving the court. And this man was still successful in leaving without prosecution. Alternative method. Simply telling the court that I reserve all my rights per UCC 1-308 and they would immediately let you go. Before. But not anymore. They keep coming against you, trying to trick you into their jurisdiction, which most people fall for. Filing documents into their court and motions gives them jurisdiction. So they take the opportunity to deny everything and keep on working against you. However, UCC 1-308 is the remedy to the courts. So it is a matter of figuring out how to supply it without giving jurisdiction. The following method is almost the same as the birth certificate method above. The alternative process: 1. Take a certified copy of your birth certificate certified by the state to the court with you. Do not make a copy or it is void. Do not mark on it or it is void. 2. Write down what you are going to say. You will be nervous and forgetful. 3. When they call your name, you walk up to the bar, but do not cross it. If it is a court of record, ask them, are we on the record? Once you are satisfied you're on the record, you can proceed. If they ask your name, ask again, are we on the record? If it is a misdemeanor, a lot of times there is no record, so just proceed. 4, then say, I'm here on special appearance. Let the court show that I, your first name only, reserve all of my rights per UCC 1-308 and I do not consent. Then turn around and leave. Do not stop. Do not answer any questions. When they say, hey, you stop, keep on going and get out. The following is a suggested way to handle the situation for the one fellow that might get grabbed. Do not resist if they lay hands on you and force you into the well of the court. If they do not answer to any name. If they say, Mr. whatever your name is, while walking to you, say, I am not that person. I'm the beneficiary, and I reserve all my rights per UCC 1-308. The judge may start asking you questions like, who are you, your name and address, etc. This is all a trick to get you into his jurisdiction. Once you give them your full name and your address, they have you. Simply say, that is immaterial. I'm the beneficiary, and I reserve all of my rights per UCC 1-308. If they ask what to call you, simply say, you can call me the beneficiary. If the judge threatens you with contempt for not giving your name or answering his questions, simply ask, can anything I say be used against me? They usually will not answer you, or they may say yes. Then you remain silent. If he threatens you over and over, keep asking, can anything be used against me? Or you can answer, I do not understand. Sometimes they will take your ID from your wallet and ask you why your picture is on it. Say that proves I'm the beneficiary. Note, you had to show your birth certificate to get a social security number or driver's license. The birth certificate proves you are the beneficiary who can receive it. If the judge tries to find you in contempt for not answering, others reported only being held for a few hours as a scare tactic, then they were let go. They cannot do anything to you unless you give them your name or address. Ever notice that a cop asks or yells, what is your name? They have to have your name to do anything to you. Then ask, is the matter settled? They will try to hand the birth certificate back to you, but do not take it unless and until they say the matter is settled, excused, or something to that effect. If the judge leaves the courtroom, he is trying to restart the proceedings because you have won. So say, let the record show that the judge has abandoned the case and now the case is closed with prejudice, and then leave. The only thing you may get is a nasty threat of a bench warrant in the mail or an order to pay a fine. But this would be only a trick. If they could do anything at all, there will be an arrest warrant the first day. I will make notes before I go in so you do not lose track of what you are doing. Once you get nervous, it's hard to remember everything. I always take my time and do not let them rush me. Talk slowly. They only do that to intimidate and to force you to make a mistake. Say, I do not understand over and over again, regardless of the question. If you do not understand a question, do not answer it. Say, I do not understand. In fact, you can say this to any question the judge asks, such as, what is your name? Court tricks. They sometimes start offering plea bargains. The only way they can get you is to scare you into a plea. Without jurisdiction, your permission, they have to let you go. I have seen this work in courts 100% of the time, but there can always be an exception. When you say, I do not understand, the judge will ask you leading questions like, do you understand English? Can you read English? And etc. If you answer yes, then he can assume you do understand. Simply say, no, I do not understand. The judge may say, you answered me in English. You do understand. Say, I do not understand. I do not understand is a great way to answer everything. After you tell him you are the beneficiary. And for the nervous types who cannot think under pressure, it is the best way to answer at all times, places, and circumstances. Rarely do folks get this hard of time, but do prepare for it just in case. If you stick to your guns and not take a plea bargain, etc., charges have always been dismissed. If you are ever arrested for anything in the future, never give your name. Say you are not that person, but are the beneficiary and living so. Used to be that they would hold you for 72 hours and then let you go if they could not get you to say your name or to take bail or bond. But now they can hold you up to 10 days and then offer you a bail or bond or return of your own recognizance. This is a trick. If you accept the offer, you are then giving them jurisdiction. They have let you go. They have to let you go sometime and then after 10 days anyway. I'm not the person and it would be bond fraud for me to accept. Let me go. The judge will sometimes address you saying, Mr. Smith this and Mr. Smith that. If you answer to the name, then again you are that person. The judge just tricked you into his jurisdiction. Simply say, I don't know who you are talking to. I'm not the person, Mr. Smith. I'm the beneficiary, and I gave you the person per the birth certificate. Note, if you ever notice when someone files a lawsuit, the court will dismiss the case, saying that it is frivolous. What they are saying is that you cannot be the plaintiff because you are not the beneficiary. So always attach a copy of your birth certificate to the suit. All rights reserved without prejudice per UCC 1-308, all lawful reservations. Without prejudice per UCC 1-308, above or below your signature on an instrument represents the following. It's not a promise to appear and eliminates perjury. Enforces the right to contract, right to compromise, and unconscionable contract. Contract reserves all applicable rights in Bill of Rights and Article 3, judicial power under the common law. Criminal intent must be brought forward to proceed. Oppose separation of powers. All terms constitutional dealing with contracts, judicial, and taxes. Reserves jurisdictional issues. Estoppel of subject matter jurisdiction and summary amorality. Non-assumpsit. Habeas corpus. Activating clause for police power at probable cause. Disrupts penumbra doctrine. Confession and avoidance. Miranda will be given for you to sign. Reserve your rights on this instrument by not becoming in persona at Rule 12b. Do not give up your persona to power of attorney because you waive rights with each admission or tacit response answered by a person standing in your stead, which makes you in which makes you in persona for accepting this benefit. Remain silent, and the reservation will command you to justice. Without prejudice, UCC 1-308, above or below your signature not only puts a condition on an unconditional contract, but also reserves all your rights under Article 3 judicial. Voids police power unless crime and probable cause exist. An unconstitutional statute, though having the form of law, is in reality no law and imposes no duties, confers no rights, no office, bestows no power on anyone, and justifies no actions performed under it. undr 2D, Section 258. The graduated income tax, for example, is unconstitutional only if the citizen abates its color of law without prejudice to him. Abate, put an end to its effect. Without prejudice serves notice upon any agent that you are not waiving any of your stated Bill of Rights. Beware of agency procedure and sign everything with the reservation to make the instrument non-assumptive, free of liability. Black's non-assumptive. The general issue in the action of assumptive being a plea by which the defendant avers he did not partake or promise as alleged. But whenever the judicial power is called into play, it is responsible to the fundamental law, and no other authority can intervene to force or authorize the judicial body to disregard it. Yakis versus U.S. 321 U.S. 414, page 468, 1944. The officer may not know the law and will probably proceed with whatever form is to be taken per his training instructions. He is a ministerial officer of the court and is given very little discretional knowledge. When our rights are violated by agency, we must cooperate with constitutional remedy and recourse. When our rights are violated by agency, we must cooperate with constitutional remedy and recourse. The agents must sign forms also, and these become a permanent record of the administrative process that will receive your judicial notice. Our state citizenship is brought forth along with our personnel rights, which do not mingle well with statute procedure. The purpose of your court appearance will be to gain jurisdiction over the personnel. I would suggest that for study purposes, that you answer politely that you do not understand the charges and without prejudice under Uniform Commercial Code 1-308 due to mistakes in fact and law, I wish to remain silent. The magistrate will have to be very constructive in his color of law procedure because his boundaries to engage you further are abated. Without contract or tacit consent to the jurisdiction, their claim is finished. Remember, you are in an Article 1 inferior court brought by admiralty, and the only power this court has over the sovereign citizen is to give remedy or take the issue to the grand jury for indictment under Article 3 if there is criminal intent. The Amendment statutes no person shall be held to answer for a capital or otherwise infamous crime unless on presentment of a grand jury. If there is no victim and criminal intent, there is no crime. It may, however, be considered settled that letters or admissions containing the expression in substance that they are to be without prejudice will not be admitted in evidence. An arrangement stating that the letter was without prejudice was held to be inadmissible as evidence. Not only will the letter bearing the words without prejudice, but also the answer thereto, which was not so guarded, was inadmissible. Ferry versus Taylor, 33, MO 323. Durgeon versus Somers, 17, Massachusetts, 55. Malinick v. Collier, 13, Georgia, 406. When we the people are put into a circumstance of compromise, the only viable solution relies on the Uniform Commercial Code and its direct link to the Constitution of these United States of America. Important, UCC 1-207 was moved to 1-308 to hide it from the public. If all goes well, you may be put on a red flag list. There appears to be 3 red flag lists. 1, the judge's list appears to be a list of people against whom the judge will not issue a warrant of arrest unless they cause injury. But the judge will still let the police ticket you or arrest you. 2, the state list, a list of people where there will normally be no arrest warrants, but where the police cannot arrest you or ticket you or detain you unless you are causing injury. You are only protected in the state that has put you on their list. If you move to another state and change to the new state's ID, then you can get tickets and or arrest to be arrested. 3, the federal list is like the state list, except that you are protected in all states and territories. However, you can no longer get on this list by sending the federal judge a letter of your reservation of rights. You have to sue your way onto this list and possibly appeal. How UCC 1-308 works. The U.S. Constitution establishes the court's jurisdiction as common law, equity, and amorality under Article 3. Okay, man, I'm gonna end this video and I'm gonna start back later. And I guess that'll be part 4. Fresh Out West, America Best, Naptown Legend. Like the video, subscribe to my channel.